Choice and consent are crucial concepts in data protection because they ensure that individuals have control over the collection, use, and disclosure of their personal information. The requirements for choice or consent vary between different jurisdictions, industries, and sectors, different categories of personal information, or types of processing activities and purposes of collection. Sometimes consent could be required for transferring personal information. Welcome back to the Privacy Power Up series. I'm Maciej Piszcz and a manager of quality assurance at TrustArc. Let's take a step back before we talk about choice and consent more. The first step for the organization could be to document data inventory and make an assessment on the categories of data collected and the purposes for the use and disclosure you are envisioning. For example, do you need sensitive personal information to achieve your goals? What are the jurisdictions and sectors you operate in? What are the types of data and purposes for processing? Does your company engage in cross-contextual advertising? Now, when you have made the assessment, the next step is to determine the choice mechanism you need to provide to comply with the various privacy regulations. Think about the OECD principles, especially for collection limitation. There should be limits to the collection of personal data, and any such data should be obtained by lawful and fair means, and where appropriate, with the knowledge or consent of the data subject. Use limitation. Personal data should not be disclosed, made available, or otherwise used for purposes other than those specified in accordance with the collection limitation principle. Most privacy regulations are based on the OECD principles. APEC Cross-Border Privacy Rules, CBPR. Consider APEC CBPR if your organization operates in APEC economies. The CBPR principal choice includes requirements to provide choice for individuals in relation to collection, user, and disclosure. The mechanisms must be operational and displayed in a clear and conspicuous manner. Opt-in versus opt-out. There are two main concepts of choice. Opt-in consent and active affirmative action to indicate choice. Examples could be checkboxes, radio buttons, etc. And pre-checked boxes would not be acceptable here. Opt-out. There could be an unsubscribe link, for example, for a newsletter, depending on the privacy regulations, or a link to opt out from selling or sharing. Please note that depending on the processing activities, industries, categories of personal information, different types of choice mechanisms will be required. The consequences and actions required by an organization can be different. This may include ceasing processing and deleting the personal information, and informing vendors. For example, CCPA, among other mechanisms, opt out from selling or sharing. Individuals must be presented with a conspicuous link to exercise the choice, or an alternative offline method if a business doesn't operate online. EEA countries, for example, depending on factors such as the legal basis or categories of personal information, different types of choice will be required. Consent, for example, cookie consent mechanism, dropping cookies for certain processing activities, legitimate interest, right to object processing based on this legal basis. Data privacy framework. Among others, an individual should be able to exercise the opt-out choice of having personal information used for direct marketing at any time, subject to reasonable limits established by the organization, such as giving the organization time to make the opt-out effective. You will need to think about the technological means of providing choice, including consent, and to make sure that the organization honors the individual's preference. This is important to have written procedures and technical measures to, among others, record choice and ensure that appropriate action has been taken when an individual exercises choice. You will need to include disclosures and working mechanisms in your privacy notice, depending on the regulatory requirements, an email to privacy office, a link to a preference manager, or specific link like under CCPA that states do not sell or share. Note that for the choice and consent when collecting or using data of minors, you should always look specifically at what your local laws require you to do. Some other areas to consider are the mechanism to withdraw consent, the form of consent that meets the regulatory obligations. Most regulations require choice to be specific and provided for prescribed purposes. So, if you want to use the information that was provided based on the consent, you will need to obtain another consent that will be specific. Note that some laws may also require you to obtain consent for transferring the data outside of the jurisdiction. For example, there may be laws that require data localization due to the sensitive nature of personal information in scope. The transfer will require consent. That's all for this segment of the Privacy Power Up series. If you haven't already, go back and watch the previous videos in this series that cover these topics. Getting started in privacy. Data collection, minimization, retention, deletion, and necessity, data inventories, mapping, and records of process, individual rights, otherwise known as data subject rights, and privacy contracting. Next up, to help you power up, is international data transfers and onward transfers. Thanks for watching.